This is Roland Mumford with Mumford.law. Wanted to do a video today about an important matter. There are a number of states that are shifting state discrimination statute enforcement provisions from state agencies to their state attorney general office divisions. And some states have a neutral, transparent, independent state agency that enforces their state's employment discrimination laws. And that independence allows for accountability, transparency, and independence as a state. So now there's a lot of complaints that with it going to a state attorney general's office, that's more political, because obviously attorney generals are appointed by either state legislatures, commissions, or the governor. This happened in Tennessee. They just shifted enforcement of the Tennessee Human Rights Act from the Tennessee Human Rights Action Commission to the Tennessee State Attorney General's office, who has an employment division. This has created a lot of concern about whether there would be continuing to be a 300-day tolling period for complaints for the EEOC charges, or would it be 180 days like it is in Georgia, where there is no state human rights action statute. Tennessee has just confirmed that the EEOC in Tennessee has cooperated with the Tennessee Attorney General's office, and there is now a workforce agency work share agreement. And that will therefore allow the 300-day period to continue. What that means is that when you file an EEOC charge, you can complain about any discriminatory acts going back 300 days from the date that that EEOC charge is signed and dated. Whereas, let's say in Georgia, it's 180 days. So look at your state. Texas started this trend back in the early 2000s, and then Maryland did something similar, and there's a few other states now doing it. So speak to an employment attorney in your state to find out about whether it's 180 days or 300 days on that tolling period to do the EEOC charge. That is now a political trend in these states, to be shifting enforcement of state Human Rights Act statutes from state agencies to attorney general's provisions. Now, I'm not too concerned about it, because many of these state human rights action agencies are feckless and paper tigers. They don't really do anything. Most employment attorneys file everything through the EEOC and want to file in federal court. But sometimes you may need to use your state discrimination statute, because if, for example, in Tennessee, if you have a fact pattern and the company only has 8 employees or 9, then you can file in Tennessee. Whereas with a federal lawsuit, the employer has to have 15 employees or more. So I just bring that up as an example. So have a great day.